So good evening, everybody. As the moderator of this webinar, which is titled as Navigating the Stages of a Civil Suit in India, which is organized by Lawctopus Law School, I would like to officially welcome you all to this session. My name is Diksha Chauhan, and it's an honor for me to moderate this session for all of you today. So as somebody from the law background and with experience in practice, I know how important it is to be aware, of the entire roadmap of a civil case. So in India, civil cases generally takes, years or sometimes even a decade to settle. So it gets even more important to know what the entire procedure is. Since all of you know what this webinar is organized by Lawctopus Law School, I would like to take this opportunity to brief you about its vision. To start with, LLS offers a host of practical courses, which helps in actually bridging the gap between theory and practice, right? So that practicing advocates can brush up their skills and students can, get more informed and equipped with what they set out, when they step out of their law schools. So we'll just begin in another minute because I still see that attendees are joining in. So till the time, more attendees are joining in, let's get to know about the agenda of, today's webinar. So we'll be discussing the various stages, in a civil proceeding. So from the initial filing of the plaint to the final judgment, and then over on to its execution, and then finally, if appeal, if there is a chance, so that participants can have a solid grasp of the entire legal processes and nuances that civil law has to offer. So this, along with that, we'll also be discussing best practices, strategies, which can enhance the effective handling of a civil suit, because we have with us a practicing advocate. So he'll be telling you about, all of the strategies that he has been personally using, and also about his own examples, his own practical examples. So you understand basically by what has been already done by a practicing advocate. So that's there. Apart from that, because primary work of a lawyer, as I can put it as, is basically how to strategize, right, on how we should proceed in a further case, because there are multiple options that are available with an advocate. So which option to pick up from and which option to, let it go, that depends on the advocate's capabilities and acumen. So that's there. And as they say that, with a good strategy, it actually means that the half of the battle is already won in a, lawsuit. So that's there. So we'll be doing all of that by discussing some real life examples, some case studies, so that all of you can, relate to it, and it can, make you a better relatability to the entire session, so that all of you young professionals can, apply that knowledge in practical scenario, right? So join me in welcoming the, speaker of the day, who will be leading this session and will be giving us practical insights into various stages of a civil suit, and building upon the knowledge that we already possess in this field, right? So we have with us Mr. Gaurav Mohanty, right, who's a practicing lawyer in Bombay. And prior to him being an independent practitioner, he has also worked with SAM. SAM stands for Shardul Amarchandan Mangaldas, as a senior associate in their DRT team, right? And then he's also a gold medalist from Symbiosis Law School, Pune. So kudos on that. And rather than that, he has also submitted and published various research papers in various journals of Nalsar and NLU Jodhpur. That is also to his credit. And he's also written various blogs, articles in various media houses such as The Wire. Then you have Bar and Bench, amongst various others. So some really amazing credentials, sir. That's it. So thank you so much, for taking out time on a weekday. I know it's court, even though today's Eid, but yeah, still. So thank you so much time for taking out time. So without any further ado, we'll commence with the practical learning of a civil suit. But before, the beginning, there are certain ground rules that need to be set. So all of the academic related questions that you have regarding this webinar will be put it in the question and answer box. So you will be seeing two kinds of boxes. One is Q&A box and one is the chat box. So all of the questions that you want the answers to, you should put that in those question answers and box. And the chat box is for any other discomfort that you have, or anything that is, that's missing. You can put your queries in the chat box, but questions that you need answers to from the faculty or from the speaker would be there in the Q&A box, right? So lastly, before I, move on, I'll give it to Sir. So there's a big surprise that is waiting for you right at the end of this webinar. So make sure to stay, put till the end of the webinar, because, you wouldn't want to miss the chance of that. So with all of this information that I have conveyed, I'll pass the stage to Sir. So Sir, it's all yours.
Thank you so much. Hello, everyone. I understand some of them did mention about the chat box is disabled for them. So I'm sure Lawctopus will be looking into that. So this is like a teaser course, like a teaser trailer for the Oppenheimer movie. Think of this as a teaser trailer for the civil drafting course that which we will ultimately embark on. Today, we're just going to have a conversation about what a civil suit is, what are the different stages, try and give you a quick summary of the CPC classes that I'm sure you're kind of missing out on in classes, because I remember my civil CPC classes in law school were the first class in the day. And it used to be always around this 8 a.m., 9 a.m. slot, and it was so difficult to make it to those classes. So before we actually begin, I want to, rather than take you through a PPT, which we will eventually go on to, give you a dispute scenario so that whatever I discuss henceforth, you can apply that to the facts of the case which I'm discussing. Okay. So if your chat box is enabled now, please give me like a raise of hands to know how many of you guys know about Avengers. Okay, I'm assuming that a lot of you guys do. Okay, I hope you guys know who Tony Stark, Iron Man is. I hope you guys know who Captain America is. Okay, so let's create a fictional dispute where these guys are based in India, right? And Tony Stark's father, who was probably can be credited with the invention of the Captain America shield, wants the shield back from Captain America. Okay. Now, Captain America does not want to give the shield back, right? So I hope the dispute scenario is clear. Again, to break it down into a nutshell, Tony Stark wants the shield back. Captain America does not want to give it to him. Think of it like Captain America Civil War, the legal version. Okay. All right. So now time for me to do some PPT sharing. Just a second. At any point of time, if my voice is not very clear, please mention it in the Q&A or the chat box. I'm sure Lawctopus will then notify me and we'll do the needful. The second thing that will eventually happen is, for some reason, my Zoom is misbehaving. So it will look like there's like a flash of light on my face. So just bear with it. It's just going to, be there for like 2-3 minutes. And I'm sure that camera will then start behaving well again. All right. So the first stage, just a second. Okay. So before we actually get into the nitty-gritties of what the stages of civil litigation is, what exactly is a civil suit? What is civil, let's say, in contrast to criminal? Interestingly, civil suit has not been defined anywhere, either in way of judgments or by way of the statute. It's a negative definition. It's basically what is not civil. So let me go in that route itself. First, let me distinguish it from what is a criminal proceeding. Criminal proceedings at its very core deals with in rem rights. I'm sure you remember in torts, in rem and in personam. But I'll just quickly go revise over those concepts. In personam means a personal right, when it is my right. Let's say if you take an umbrella and knock it on my face, it affects only my rights, not the rights of the people around me. So that is called a in personam rights. In rem rights are rights which are enjoyed by the society as a whole. For example, if you are inclined to commit murder, while you're actually injuring a person, that is a crime against the very fabric of society. So that becomes an in rem right. For example, the right to breathe clean air, and all these environmental law judgments that you will, I'm sure, no doubt be reading about. In these judgments as well, they are dealing with in rem rights. So while this is not, there are exceptions to everything, but criminal law generally deals with in rem rights, whereas civil suit deals with in personam rights, right? The objective of both these kind of suits also differ. For example, criminal suits, criminal action would be the objective would be to get the other side, like whoever you're going after, they should be punished either by way of imprisonment or fine or both, depending on whatever the crime is or punishment for that is set out under the IPC, right? In civil cases, generally the objective is to get compensation, either by way of monetary damages or by way of getting them to stop like doing something. And because, okay, let me give you an example. Let's say you have a building, you're paid for a flat in a building, right? And the government wants to demolish it. And you're obviously concerned that, okay, that's your investment, it should not go away to waste. So you approach a court stating that please stop the government from doing this. And that can be a civil proceeding. I hope you're getting it. It's like your personal right. On the other hand, criminal action will deal with, let's say someone has kidnapped you and abducted you rather, and the cops have caught them and you want them punished, right? The objective here is punishment. The third difference when it comes to these two concepts is that criminal proceedings, like the max you can do, let's say you have a client who wants to pursue a criminal action against someone else. The max you can do is file a complaint with the police, because every criminal action is prosecuted by the state. Like, you must have heard the term public prosecutor. It's always the state that pursues criminal action. That's why, as I said, right, sometime back, that the criminal law deals with in rem rights. And in rem rights, who's the custodian of that? The government. So in that case, if it's related to a state matter, the state public prosecutor, the state will do it. If it's in the central government will appoint someone, but it's always the government who's representing you. At the max, what you can do is just file the criminal complaint. On the other hand, in a civil suit, you can appoint your own lawyers to go and fight the case. You personally fight the case. It's always going to be Gaurav Mohanty versus Lawctopus, right? It's going to be something on that scenario. On the other hand, when there's a criminal case, is generally Gaurav Mohanty versus state of Odisha, right? I hope that makes some kind of sense. So that is the general conceptual difference between these two things. There is a further carving out that has been done when it comes to civil suit. See, under CPC, civil suit is any action which you bring before a civil court. Now, what they have done is they have created special courts to deal with special matters, right? And if at any point of time this gets overwhelming, please feel free to write down your doubts so that you can ask me when we take a half-an-hour break, okay? Right. So now, because I mean, anyone who has seen the Sunny Deol line, the movie, right, where he says Tariq pe Tariq, knows that the Indian judicial system is very overburdened with litigation. So to cure that, well, it has not been cured, but to cure that, the government came out with specialized courts to deal with specialized matters. For example, now company matters, which earlier could be classified as civil suits, now go before the NCLT, right? Similarly, when banks have to see, banks are very important for the functioning of any economy, right? It's very critical for banks to recover money from defaulters. Now, they can't wait 10, 15 years, general time period for any civil suit to resolve itself. So for them, again, a special act and a special forum has been made, which is called the DRT, the Debt Recovery Tribunal, right? So these matters are no longer civil matters stricto sensu, not strictly speaking. They have been carved out and they go before different courts, right? This is something which you will understand deeper when your client comes to you and tells you, okay, this is my dispute, this is what I want. And then you check on the subject matter and see, okay, where this matter should go before, right? Regardless of whether it is a civil suit, is it a property matter, if it's recovery of debt matter, or if it's a consumer matter before the consumer forum, the stages, however, 99% of the time remain the same. So this webinar, which we're going to undergo right now, is going to give you a brief bird's eye view on what are the different stages, right? All right, so that's enough of introduction. I think we should dive deep into the meat of this entire webinar. All right, so let's go to the second one. Right, so where were we? We're discussing about remedies which Tony Stark will have. Now, Tony Stark approaches you and you're a very well-to-do lawyer. The Stark Industries has come to you and has asked you, what should I do now? I want the shield back and he's not willing to give it to me. Right? Obviously, the public, PR media, everything is on his side because everyone loves Captain America. So what do? first thing before filing any suit is to try and settle it. As a lawyer, that's your primary duty. Because if you can settle the matter before it goes to the court, you save so much time, right? Rather than waste 10 years lagging in courts, going through the numerous stages, you can just settle it beforehand. So how to initiate that? The starting point of any dispute is a legal notice. See, I'm sure Tony Stark might have sent a lot of notices to Captain America before. So, please give it back. I'm sure they have a lot of correspondence, etc., etc. But a legal notice is something which is carefully drafted. It's not generally way too long, where you set out what your claim is and you give them a chance that within 7 days or within a month, depending on your client's dispensation, return the shield back to me, or you'll be liable for any consequences that may follow, which may include legal or otherwise. Right? That's generally the end paragraph which we write. It kind of gives them a chance to, rectify the wrong. See, most of the times, like in my career as a lawyer, I have never seen anyone respond favorably to a legal notice. It's not that disputes get unraveled just because you send a legal notice. But the practical impact of that is that you set out your dispute, and it also shows to the court your willingness to try and settle this before it actually went to court. Right? Legal notice is also a way of letting the other person know that, hey, I'm going to file a suit if you don't respond to this. Right? Because if you straight away go to a civil suit, there are emergency situations where you have to do that without giving a legal notice. But in the non-emergency situation, the court does not look kindly upon the fact that you never even gave them a chance to rectify or remedy their wrong, or at least tell what their side is. Right? So in that case, legal notice becomes very important. So once, how did we send a legal notice when we were in SAM, or when I'm even working as an independent legal practitioner? The client comes to me, he gives me the correspondence. Now, don't attach any of the letters, nothing. Legal notice is a simple legal paper. I write down the address of the party, the registered, let's say it's a company. Let's say Captain America has a company. Okay. I will find out from the MCA website, which is the Ministry of Corporate Affairs website, their registered office address, because that's what counts. You can't send it to their corporate office, right? Maybe I think, striking too high, but just I'll explain this concept because this really helped me in my internships. Okay, so a lot of companies, right? Like might have their big, huge, glassy building offices, etc. in Delhi or in Gurgaon. But they might have their registered office in Bombay, in Mumbai. Right? In that case, just sending them a notice in Delhi will not suffice. Because even if that's their main office, because for the purposes of Companies Act, their registered office is Mumbai. And under the law, you're supposed to send the notice to their registered office. Obviously, since we were we were doing our due diligence, we used to send the legal notices to both the addresses just to ensure that our bases are covered, right? So we used to just set out the dispute in like a paragraph, nothing too long. You don't have to annex each and every correspondence or write each and every trace the history that, okay, my Howard Stark had made this shield, you had taken it, Hydra had been involved, Avengers fought in the Battle of New York. You don't have to write so much yada information. Just write that this is a proprietary owner, like Stark Industries is the proprietary owner of the shield, and given that you are the heir of Stark Industries, you are entitled to the shield, so return it to him within 7 days. That's it, a very short one, and just ask them to remedy that defect within 7 days. Now, obviously, what Captain America can choose to do here is either respond to it, denying it completely, stating that I do not believe in any of the allegations you're opposing, and that the shield has always been mine, and so on and so forth. Or he can just choose not to respond to the notice. That's perfectly fine. He's not at fault if he decides not to respond. But once the time period lapses, whichever you have given him to return the shield to you, then you're eligible to actually go and file a suit, right? And this is when we come to the starting point of litigation, which is filing of the plaint. Okay, so lawyers have two modes of, or two languages, so as to speak, if I'm trying to be a little poetic. One is, of course, arguments, which you all have seen in Suits and Boston Legal and all the legal shows that you might have watched. The other is through something which we call pleadings. Okay, it's pleadings. Pleadings. Now, what are pleadings? Pleading is basically something which we file in court, a document which we file in court, which sets out our case. This is a very simplistic definition. Please don't use this in your answers in your law school because it will not fetch you the marks. So pleadings can be divided into two parts. Again, these two will sound very exotic words for someone who's not acquainted with them, but it is called plaint and written statement. Okay, bear with me. If you can't understand this, it's perfectly fine. I'm going to repeat this over and over again till it's drilled into your head. Okay, so bear with me. Plaint is something which Tony Stark will file, which the first person to file a suit files. Plaint is nothing but a document which sets out exactly like, your name, the other party's name, right? Sets out what your grievance is, why you're entitled to that shield or whatever relief you're seeking, the reliefs which you ultimately seek, and you ask the court, please give this relief to me. This is what is called a plaint. Okay, a plaint, there are extremely detailed rules in CPC how to draft a plaint, and I think that's great that we do have these kind of rules. I know it will sound like it's horrible when you have to write these rules for exams, but what these rules do is kind of introduce a sort of formality and uniformity to the plaints across India. Otherwise people with different language skills will come up with different kinds of plaint and it's going to be completely like a haywire, chaotic situation, right? But CPC with its orders, annexures, rules and forms is very clear on what exactly is the information it requires in a plaint, right? Plaint is the starting point of any litigation. But no litigation can start with until someone files a plaint, right? He's the first party who files a plaint. Now, Order 7 of the CPC kind of lays down certain particulars or information which a plaint should have. Some of them are in the slide. I hope you guys can see it. It's name of the court where the litigation takes place. Okay, this thing sounds kind of obvious, right? I mean, obviously you will write the court's name where you're filing it. No, but this has a very significant importance. How is it important? Let's see. As I was giving the whole Delhi Bombay example, right? Now, Captain America has an office in Delhi, has a registered office in Mumbai. Okay, so far so good. Okay. Tony Stark has a registered office in Delhi. The shield was made in Delhi, but handed over to Captain America in Mumbai. Okay, back, when Tony Stark's father was there. Tony Stark and Captain America had this conversation about wanting this shield in Kanpur. Okay, so now you have three cities in this entire paradigm. You have Kanpur, you have Delhi, and you have Mumbai. So where do you file a suit? Again, CPC has laid down detailed rules regarding the place of suing. Which court has a jurisdiction to hear the matter? I think it's in section 20 and onwards. I mean, the various rules, and I won't go into detail into it right now because that's not the subject matter here, but it is basically where the cause of action generally arises. Either it is where the defendant is residing or has a permanent office, which in this case is Mumbai, right? Because Captain America has a registered office there. Right? We can say that, okay, wait, Tony Stark has a registered office in Delhi, but no, it has to be where the defendant is. Because think about it. Otherwise, you can harass defendants by filing a suit wherever you want. Right? If you have a problem, let's say you're a malicious person, and you guys are not, but I'm just giving you an example. Let's say you're a villain. Okay, you're Hydra, and you want to file a suit against Captain America, who poor guy is in Mumbai, and you are in Bangalore. You will knowingly file a suit in Bangalore, forcing him to come to Bangalore and fight the suit, obviously, causing him a lot of harassment. So in this kind of scenario, generally, we file a suit where the defendant is based, right? The other exception to that is where the cause of action arises, as in where was the shield made, right? Where was the shield handed over? Where was the contract for the shield signed? These factors, as a lawyer, you're going to analyze to see which place has the jurisdiction. So accordingly, you will either file it in, Delhi City Civil Court, Mumbai City Civil Court, or Kanpur City Civil Court. But given that the shield's value is going to be enormous, considering it's made of vibranium, the value will be high. So then you'll have to decide, no, wait, I can't go before the city civil court because it does not have the pecuniary or money jurisdiction to handle this kind of suit. So you will go a step higher. You will go to high court. And then you'll have to decide whether you have to go to Bombay High Court or you have to go to the Delhi High Court. That's a call which you'll have to take as a lawyer, looking at the facts of the case. That's why, it says name of the court where the litigation takes place, but that's actually the first thing as a lawyer which you'll have to decide. Where do you file the suit? Some tidbits from practical matters. Filing of a suit, sometimes we really have to take into concern where we can actually harass the defendant a lot as well. Because sometimes what happens is multiple places have jurisdiction to hear the matter. It's not always that only one place has it, right? You can file it in Delhi, you can file it in Bombay, you can probably also file it in Gujarat. So in that case, as a lawyer, you have to take a call to see where can we bug the defendant more, so that we can bring him to the table, or where are we stronger at, where is our base, which is more convenient for us, stuff like that. So these are factors which you have to take into account. Second is details of the parties contending the civil dispute. Now, what does this mean? Generally, obviously we are writing about who the parties are, like it's Captain America versus Tony Stark. No, that's not how it works. Who actually owns the shield? It might be the company who owns the shield. It might be Captain America's company who owns the shield. So you have to implead them as parties as well. Okay, it's just not enough to name the person as the party. You have to implead who the actual owner is. So identification of parties is also very crucial. The third is, of course, facts of the case. You set out the facts of the case, saying the entire history. You annex any correspondence that you might have exchanged and attach that. And fourth is the primary thing, is the relief which you seek. Okay, what exactly do you want in this court? Okay. And the last is the documents which substantiate the facts. Like if there's any contract, if there is any proof which states that the ownership of the shield was always vested in Stark Industries and never actually in Captain America or the Indian government, or in this case, United States government, stuff like that. So you annex that to the plaint. Okay. So that's called filing of the plaint. What happens after we file a plaint? Then the court issues something which is called summons. Okay, what is summons? Sounds like honestly, I had a lot of trouble understanding what a summons is because there are multiple kinds of summons. Once a plaint is filed, okay, and obviously you have to serve a copy of the plaint to the defendant stating that, boss, listen, I have filed a suit against you. It's not that the defendant is expected to run and come and present himself. No, he will wait till the court issues a summons. A summons is basically a form which is issued by the court. Generally, the bailiff will stamp it, or there is a court stamp on it, which goes from the court to the defendant's registered address, stating that, listen, a suit has been filed against you on this XYZ date. Either you be present or you be present through your lawyer. It's a way of the court to let the defendant know that you are supposed to be present. If they don't appear, the court has the power to take action against them. So this is summons. You will keep hearing in news that Juhi Chawla has been summoned, this celebrity has been summoned. What is this summon? And we treat this summons thing as if it's like a big thing and it's like a verdict of guilt against them. Generally, the laymen do. At least my parents used to. But no, summons is a very innocent thing. It's just basically informing the other side that, listen, a suit has been filed against you. Please come here and make your case, so that the suit does not proceed without you, or as the legal term is, ex parte. Okay, so that is summons. Then we have written statement, which is the second leg of the pleadings. We discussed pleadings some time back. So if a plaint is filed by the person instituting the suit, a written statement is the document which is filed by the defendant, right? So the party who files suit is called a plaintiff, who files a plaint. And the person who is on the other side is called the defendant, who files a written statement. A written statement, there's a time limit which is given under the CPC, which is slightly more stringent when it comes to commercial suits. Generally, it varies from 30 to 90 days. Obviously, a defendant cannot take like 2-3 years to file the reply. It will defeat the entire purpose of litigation. There's a time limit which is given within which the defendant is supposed to file its written statement. There are, again, very detailed rules regarding the drafting of written statement, which we will go in detail when we come to the drafting course. But suffices to say that in a written statement, you're supposed to refute each and every allegation of the plaintiff. In the no, I disagree, I deny, he's ridiculous, Tony Stark is completely egomaniacal warlord, stuff like that. In the written statement, we can also make claims like, no, but Tony Stark owes me money for the same transaction. So if he wants money from me, he can cut it off from there. Stuff like that. The legal term for this is set off. We'll again go into this in detail later. But right now, the next stage is basically written statement. The defendant files his version of the case, right? All right. Then we come to where the judge finally gets involved. Okay. This is called framing of issues. See, the plaintiff might have given in his entire Mahabharata in his book, in his plaint. Okay. And the defendant might have given his entire Ramayana in his version, in the written statement. Okay. The stories might completely diverge. What is a judge's duty? To bring them back to the fighting pavilion. And this he does by framing of issues. Like, what exactly are the questions this suit seeks to answer? In this case, the issues might be, okay, who made the shield? Was the shield transferred? Was whether Captain America is liable to return the shield? Maybe he can form 3 issues like this, whose answers will help him coming to the judgment of this. Right? Issue is like a compass or like a North Star that helps keep the proceedings streamlined. So the plaintiff and the defendant do not stray away from it and stick to it. Right? When we file it, generally, this is the practical thing. Generally, the judge is supposed to frame the issues on his own, and that the judge does. But what both the parties sometimes do is frame draft issues, and we submit it to the court, saying that, okay, these are the issues that we think are the issues. The defendant might also submit a similar list of issues. The judge looks at it and frames one common list of issues and reads it out on one date of hearing. Okay. All right. So that's the framing of issue in civil suit. How about we just take a quick break here? Is that okay?
Yeah, meanwhile, we can take questions as well.
Absolutely. So let's just take a few questions.
Yeah,
because
since
I
the
think I've
pleading
bombarded
part
you with
is
a lot of
over.
them.
Yeah, since the pleading part is over, we've discussed plaint and written statement. Okay. So, so can you please establish the steps from point A to point Z of civil commercial litigation process?
Okay, so Sangram, that's what I'm doing right now. So we've just come from point A to probably point C. All the rest of the points will be discussed as we go on. Don't worry, this entire webinar is about discussing point A to point Z. So that's
okay.
fine.
Next question is, how many summons are generally issued?
It again depends, because like generally when the defendant answers the first summons, they're supposed to they come in, and there's obviously no need for issuing another summons. But courts, or rather the court registrar, to be honest, judges are never directly involved in this. The registrar handles these matters, does give a few more chances. In Bombay High Court, generally what have been used to, they generally give 2 to 3 chances, before ultimately deciding the suit will be proceeded ex parte.
Okay, so is violation of tort a civil suit?
Yes, it is. It is.
Okay, that's a pretty direct answer. Okay, so notice under the CPC is this concept which we discussed. Is like what we discussed, is it notice, which is defined under CPC?
I'm sorry, I did not get that question. Come again.
So there is a section specifically dedicated to notice under CPC, right? So what we discussed right now, is it the same notice?
So like when you have to issue a notice, right, a legal notice, that does not have to adhere to the requirements of CPC per se. Because see, CPC deals with documents which you are filing in court. But it is advisable to like stick to that format, because it's just like a template. There is nothing different between what you will normally write in a notice. As I said, in a notice, all you have to do is give them time to, fulfill whatever defect that you're talking about, right? And if they don't fulfill in that time, you basically write this line, that failing which you are inviting all sorts of legal consequences, including but not limited to blah, 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 civil action or blah, 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 criminal action. So that's more the wording which we use. The CPC is not that detailed on it, but you don't have to adhere to that format when it comes to legal notice, because that's between the parties. That does not involve the court yet.
Okay, so another question regarding law of torts. So are those cases heard by courts? Are the cases under law of torts heard by courts?
Yes, the cases are heard by courts. I'm not sure if I understand this question, but if you have a tort, like let's say let's pick up a tort example.
Nuisance, negligence.
Yeah, I mean, let's do the simplest example. Okay, if someone's just, the whole umbrella thing where this famous quote came in that your right to swing your umbrella ends where my nose starts. Okay, so let's take that example. And someone's like, bang your nose. And obviously you can take criminal action, but you can also go for, I don't know, trespass or something on those lines. And when you do that, you go before the court only. There's no other party you can decide. Because tort, in that sense, is a civil remedy, which you can see. Unless, which I cannot imagine, I'm trying to think of a scenario where you guys have a contract with each other where you will deal with tort before an arbitrator. I've never seen that happen. But no, I think it'll still be decided by the courts. Yeah.
Okay. So another question for you is, sir, that can you please give us an example of the emergency situations where no legal notice has to be given to the opposite party?
Okay, just give me a second. Yeah. Building demolition is definitely one case. I mean, think about it. When the Bombay BMC was going to demolish or actually set out to demolish Kangana Ranaut's office, this was a very famous case. She approached the court. She had no time to give BMC a legal notice stating that, listen, please stop, don't do this. She had to approach the court stating that I need emergency. Please don't let this happen. Or let's say a scenario where you need money. There's like a money thing, where someone was supposed to give you money in respect of a crate of oranges, very rare oranges that you deliver to them. And they're not paying you. So naturally, your course of action is to send them a legal notice. But you realize that that person is basically investing all his money in some FD, which will be locked for 6 to 7 years, a fixed deposit. So you're afraid that the money which he could have paid you with is going to go away from his hands. So even if you actually get the judgment, he will not have any money to pay you with. So in that case, you immediately go to the court stating that I had no time to give him a legal notice because he's planning to. I think my camera is misbehaving again, right?
Yeah, a little bit, but it doesn't matter. I mean,
yeah, okay. So in that case, I go to the court and say that, listen, please stop him from, doing whatever he's doing. Stop him from taking his money out of the reach of court. And I need urgent interim relief. So please give me that relief. So in that kind of a scenario, we stop them from taking such kind of action, and we don't have the time to give them legal notice then.
Okay, so we'll take 2 more questions. So one, both of them are on summons. So first is, what are the types of summons, right? And how many summons can be issued before actually an ex parte order is passed?
Again, on practically speaking, again, as we already spoke about the number of summons which can be required. Like I have had cases where the registrar has given multiple chances. It's not that they issue multiple summons per se, but they give them multiple opportunities to make appearance before them. Okay, like the matter is listed for appearance of the party. The party has not appeared. So they will give another date stating that, okay, we'll give them another chance, right? And how many so what was the other thing which you asked?
How many number of summons? First was that what are different kinds of summons, and how many summons can be issued before actually an ex parte order is passed?
So see, types of summons are generally 2 kinds. When one is, of course, asking the defendant to appear, and the other is asking a witness to appear. I'm guessing this is the kind of classification of summons that you're asking. Again, the summons differs greatly when it comes to a criminal matter where it is a lot more serious and where penalty for non-appearance and chances given for non-appearance are like far lower as compared to a civil suit. And in civil suit, summons are issued at 2 stages. One is, of course, when you're asking the defendant that, listen, you please appear, someone has filed a suit against you. The other is when, as a plaintiff, where, like, say, as I said, I'm Tony Stark, and I think you guys can hear me, right? Despite the whole video thing.
Yes, perfectly.
Right. So in that example, if let's say Black Widow is one of my witnesses, right? So, and let's say Black Widow is not willing to come on her own accord. So I will list her as a witness before the court, saying that she is one of my witnesses. The court will then issue a summons to her, saying that you have been named as a witness in this case. Please appear on so and so date to give evidence. So I guess that's the 2 classification of summons you can look.
Okay, so one more on summons that we'll take. That what is the procedure if someone is not obeying the summons? Like if somebody is not obeying the summons, what is the procedure?
generally, in a civil suit, if someone is not obeying, that's perfect for you as a plaintiff, right? Because then you can proceed ex parte, right? It's not that you have to do something. In a criminal matter, obviously, it becomes a whole different thing because you're trying to impute criminal liability on them. Maybe like, let's say even in a check bouncing case, for example, in a check bouncing case, which while a criminal matter is civil in nature, what happens in that case is if someone has not responded to the summons, after a while, an arrest warrant is issued. Okay. In a civil suit, that is not required because the whole concept of arrest does not come here. The suit will then proceed ex parte against them. The registrar will mark a stamp saying ex parte and it will go on. And I'm sure after like 1-2 months, when this guy will wake up thinking that, okay, now the suit will proceed against ex parte against me and a decree will come against me. Then he will come and say, I'm sorry, I could not be present for XYZ reasons, make an application. And the court will then listen to that application to consider whether they should stop the suit from proceeding ex parte or not. And generally the court relents, sometimes by asking them to pay a fine or something. But yeah, that's it. I hope that kind of answers your question.
Okay.
Summons is a very, don't confuse summons in a civil suit with a criminal thing. I get the kind of questions that are coming, but you guys are thinking from a criminal law perspective, where the importance of summons is a lot more as compared to a civil suit. Okay. Because in civil suit, you anyway serve, you make sure that you're serving the copy of the plaintiff, etc., to the other side. So they know that they are supposed to come in, otherwise they'll proceed ex parte against them. So that's the question. And they don't mind coming in because it's not that they will be personally arrested, right? They have to defend their case. As against criminal proceedings where anything can happen. So they are very reluctant to actually make personal appearances. The other thing also, the nuance of summons, I'm sorry, I'm delving deeper into this, but since you've asked, in criminal proceedings, like I was talking about place of suing, right? Like you generally sue where the defendant is there. That is not required in criminal action, right? A crime could have, like, let's say a cyber crime, generally the way someone has read a bad tweet, or let's say people who have sued Adi Purush. Okay, that movie might have been made in the South, but people have sued them in Uttar Pradesh, Allahabad High Court. Now, they can issue summons to the makers of the movie to come there if it's a criminal kind of action. Right? And those guys will have to come there. So it is like cross-state. It's a lot of harassment, or depending on your perspective, but it can prove to be a lot of harassment to defend it. Right? So the whole notion of summons in criminal law is way more nuanced and deeper than in civil law. I hope that it raises more questions, but other than answers. But yeah, I hope that kind of goes there.
So yeah. I think we'll take the questions later on. We have a lot of questions. Right. So if we can begin. Sure. And then we can take the other questions later.
Great. But just like know the summons when they're done, that generally the court does it. It's done through a bailiff. They do it through bailiff. They will send it to the registered post. Sometimes they do it again, but rarely. They generally give more chances. That's more like the way to go it, practically speaking. All right. So we'll get back to the session. In one case, by the way, they sent a summons. Like one of the judges, he's very WhatsApp friendly. So his name is Justice G.S. Patel. And this is a very famous case. It's not my matter, but he sent us summons like through WhatsApp because they had not responded, and he just wanted to, he knew that he got the number from the lawyer, and then he sent them the summons. Some judges are very tech friendly. They do that. And he got the double tick blue receipt as well. So the defendant came running. This is just an anecdote for you guys. Please don't treat this as law. All right. So going back to the proceeding back to the session. Okay. So quickly, after you're done with the whole summons stage and framing of issue stage, we come to the inspection, discovery, and production of documents. Again, this is very detailed. Like you can do like 3-4 sessions on this itself. I'll just keep it very basic, you guys. What happens in this is, see, just because you have, revealed your entire katha in your plaint does not mean that the court will believe you. You substantiate your case on the basis of documents which you attach to your plaint. Now, when the documents are attached, the other side, or you have referred to those documents in your plaint, the other side might say, no, wait, I want to check those documents out. So the other side, a defendant, might write to the court or might write to the plaintiff directly that, please, these are the documents which I want to inspect, to see whether you have the original of them or not, or whether this is actually a genuine document, right? So this is the whole inspection discovery process. What generally happens, really boring for lawyers, to be really honest. but it's very critical. Okay, do not undermine the importance of this. But in my cases, unfortunately, they've never yielded any kind of great startling results. What happens is you go to the other lawyer's office. Okay, they give you all the original documents, you inspect it, look if the signatures are matching the photocopies or not. Look, the page numbers are fine. Generally just get a brief overview of how the documents are, and like, okay, you make a tick. Okay, this document looks fine. This document looks fine, and so on and so forth. If a document has some critical issues, it does not match the photocopy that they have attached, you make a point of it, saying that, okay, there is some glaring discrepancy between the documents that they have produced versus the documents they were annexed. Stuff like that. Why is this stage very important is once this is done, then comes the production of documents, which is the evidence stage, which is everything. Okay. In evidence stage, okay, basically you produce the originals, right? You tell the court that these are the originals, look at it and believe my claim. Now, as you guys know, most of the times we all lose original documents, right? Now, section 62 to 65 of Evidence Act contain detailed rules on this. We will again dive into detail when we actually start the main course. But there are two kinds of evidence: primary evidence and secondary evidence. Primary evidence is, I don't know, okay, let's say this is one book. Okay, this is Harry Potter Chamber of Secrets. Okay, and someone had written something critical in this. And if I'm filing this book in evidence, this is original evidence. Okay. But if I'm filing a photocopy of this book, that is called a secondary evidence. You're not allowed to furnish secondary evidence. Like, why should the court rely on photocopies? Unless you satisfy some of the criteria which is set out in the Evidence Act. For example, for some reason, I have lost this book. Okay. So then I state that, okay, I make averments in my affidavit stating that, hello, I've lost this document. I filed a FIR for recovery of the document. And since this document is not in my possession, please permit me to leave secondary evidence in this regard. Stuff like that. The other kind of secondary evidence is, okay, for example, WhatsApp chats. Is there any way to have originals of WhatsApp chats? No, because you will obviously print it. It's a digital information. You can never have the original of it. But electronic evidence, as we all know, can be easily manipulated with. So section 65B of Evidence Act has detailed rules regarding the certificate that you need to annex to all kinds of electronic evidence. And this is something which you guys really need to be well versed with, because the future of with the AI, chat GPT, all this thing coming in, electronic evidence is going to be the way forward. And now even judges have become very adept with it. So you have a certain set of rules which you have to satisfy for permitting electronic evidence to be accepted by the court. Okay, I won't go too much into those rules now. But yeah, so these are the kind of evidence which you have to produce. The other side can take objections saying that, no, 1 second, why doesn't he have the original? Or let's say if I just claim that I've lost the original, I can make an objection stating that, 1 second, has he filed an FIR? How did he lose it? He simply just can't state that I've lost it. He has to give reasons. What all steps has he taken to recover it? Because otherwise he's just falsifying a document. So these are the kind of objections like Captain America could take against Tony Stark in a similar case scenario, right? And that's why this evidence stage becomes very crucial. Remember I spoke about pleading. So you have a plaint, you have a written statement, right? Then you have an affidavit in evidence, which the plaintiff files, stating that, okay, all the documents I have, he will set out a document, write the details of the documents, and make averments from the Evidence Act to satisfy the tests and parameters set out there. I'll give one more example just so that it goes into your head. Okay, wait, let me think of some. Okay, let's say there's a contract, the whole Stark contract I was talking about, right? For handing of Captain America shield. How will I prove this document? I will write. So since a person has to do this, I identify the signatures of Howard Stark and Steve Rogers on this document by comparing their signatures with the official records available in the office. Because naturally, these guys lived a long time back. So there is no way a person who's giving the affidavit now would have lived at that point of time, right? So he has compared their signatures from other documents with this document to say that, no, I think these documents, the signatures is correct. I say that this document is an original document. I say that the contents therein are true and correct, and you make these kind of averments to prove a document. And the entire evidence affidavit is filled with these kind of technical remarks about each document. Okay, again, I know it's too technical. You will understand this as you dive deeper, but this is the main stage. Again, like, you have come from the plaint, then you have gone from the written statement, you have come from the framing of issues, then, sorry, before written statement, I forgot, issuance of summons, right? Okay, again, let's do this again. Notice, plaint, issuance of summons, written statement, inspection and discovery of documents, evidence, right? So far, so good? Okay. I have no idea if you're saying thumbs up or not, but I'm just going to go ahead with it, okay? This answers the question which some of you guys had asked about, what are the different kinds of summons. So this is the second kind of summons, where a summons is issued to a witness, who might not be willing to attend, or even if he's willing to attend, it just goes from the court so that they come and appear. Sometimes you need government officials to come in. You obviously don't know who the responsible government official might be. Let's say, I don't know, the gutters in a society are not working, right? Whoever is the responsible officer, the court will issue a summons to that department, and the responsible officer will then come in and give his version of events. Trial stage, I think this is kind of clear, where, the whole adalat thing happens. You argue your case. When we go before the court, we start first. The plaintiff starts first. He sets out the facts, produces any case laws that he might have. Then the other side gets up. He makes his set of facts. He produces his judgments. I come thereafter in rejoinder, and I might, rebut whatever points he has made. Sometimes the court permits the other side to also come in a sur rejoinder if I have raised some new points. Generally they try and keep it as short as possible. Hang on. Of course, the next thing is judgment, where the court pronounces a judgment which ultimately decides the case in either Tony Stark's favor or Captain America's favor. Now, at this juncture, I know it's not part of the whole stages of civil litigation, but I really wanted to throw some light on this, because I remember I had so much trouble, wrapping my head around this concept. What exactly is the difference between judgment, decree, and order? Okay. Again, please look at the definition in your CPC when you're going for answers. Those definitions really are very convoluted, but hello, you're lawyers. You have to use complicated legalese to sound smart. But apart from that, dumbing it down completely, this is what happens, okay? Decree, judgment is the ultimate decision. Okay, my judgment is that the shield belongs to Captain America. Okay, this is the judgment. Now, decree is the reasoning on which the judgment is made. The decree is basically the answer to the issues. A decree will say that the contract specified that Captain America will be the sole owner. And since he has owned the shield for 76 plus years, because of some XYZ law, now he owns the shield. It will be wrong to take the shield away from him. This is the decree. A judgment is basically the Mount Everest, and the decree is the Himalayas. Okay, a Mount Everest on top of the Himalayas. I hope I was able to paint a picture. To keep it even simpler, judgment is always a concluding line on the basis of a decree, right? That is the essential difference between both. Now, order is something which generally is passed by the court during the course of a trial, right? It temporarily determines the rights of the parties. And I'll tell you, I'll explain this. Now, remember how I spoke about the Kangana Ranaut case, where her property was being demolished by BMC and she had to go in an emergency situation to get relief. The court obviously does not have the time to decide the entire case, right, in the first day. But it will give an interim order, an order stating that the status quo should be maintained, which means that neither will Kangana do anything with the property, or neither will BMC do anything with the property, right? The entire thing will be frozen. No one will take any kind of action, right? This is an order which preserves the rights of both the parties, but does not conclusively determine it, which will be only determined at the end of the trial, right? So an order kind of it's just a ruling which is more in the kind of procedural kind. So see, this was slightly heavy. Let me give you an example of a little slightly less grave order. Okay, let's say you were not able to file, you're the defendant, you're Tony Stark, and you're partying in Malibu. Okay, you were not able to file your written statement in time, the time limit which is provided under CPC. So when you ultimately file your written statement, you have to file it with an application for condonation of delay. It's the entire rules are set out in CPC, which states that you have to give reasons that why exactly were you delayed, what is the number of days of delay, and you basically pray to the court that please allow this. The court 99% of the times allows this application, right? But when the court allows this application saying that, okay, I allow Tony Stark to file the written statement, that is not a judgment or a decree, that is an order, because it does not conclusively determine the rights of the parties at the end of the suit. So, right, I hope that kind of explains the difference. I think we have come to the end of the session. No, okay, I forgot the last stage. House. Once the suit is over, you have to execute the decree. See, once the judgment is out, once the decree is out in your favor, right? It doesn't mean that I, sit back on my recliner and say, oh, it's done. No, we have to enforce it. Okay, naturally, our lives are not made any easier by this rule. What we're supposed to do is then file an execution petition. If the other side has not, let's say, Tony Stark is asked to, or let's say the judgment goes against Captain America, and Captain America is supposed to return the shield or give enough money to Tony Stark. And he does not do so. So then I file this execution decree stating that, listen, he is not giving it to me. The court will ensure that Captain America satisfies the decree. And if he does not, can seize Captain America's property. There are a lot of reliefs which are set out: attachment, arrest, warrant, seizure of assets. His bank assets might be frozen. His properties may be locked, till he satisfies the decree. So that is called execution of a decree. Right. So that's it. I think this is a thank you slide. Yay. So we were done with the course webinar. I open the floor to questions. Please feel free to ask them.
We have so many questions waiting for you. So
okay.
First is
top 7.
Yeah. Yes. So first is
it's there in this one, no? Just hold on. Can I take them? Just 1 second.
Yes, you can take them. Or
okay, just give me 1 second. Okay, I need a sip of water.
Sure. Sure, definitely.
I've spoken for a while.
So in the meanwhile, all of you, if you have any questions, you can put them in the question and answer box, because we'll be taking all of your questions. So make sure, because I can see a lot of questions in the chat box. So make sure to put them in the question and answer box, and all of them will be taken one by one. Right, so we'll request. So we'll request the speaker to take all of the questions. So make sure to write it in the Q&A box. Right, and also in the chat box, just mention how was this session for all of you. That was a pretty brief into what the proceedings look like. So all of you can mention in the chat box as to how was the session for all of you. Right. So we'll just, wait for a few seconds for the speaker to come.
Sorry for keeping you guys waiting. Yes, I heard that I have to answer questions. Guys, please stop asking more questions. Please eat, and I'm very hungry. I'm just kidding. I'll try and answer all the questions.
Okay, so first one is that...
should I go through the questions? It'll be a lot faster for me.
Sure.
Yeah? Okay, so I'll just start. Why cannot I connect my AirPods? I don't know how to answer to that. Okay. Whether oral submissions are allowed before framing the issues? Not really. I mean, you don't, unless you seek an urgent relief, like there's an interim application that is there. That's when you can make your oral argument, but then the interim application is heard separately. But for the entire suit, no, the oral argument stage comes in the trial stage. So first issues have to be framed. Unless you need to really give urgent relief, right? So then you obviously make some oral arguments. So whether civil suit judgment is binding on criminal court, for example, no. No, they are different scenarios, different laws. They are not binding. It does carry a bit of persuasive value, but persuasive value is not something which is ever defined by court. So, it will definitely see, they have done a fact-finding exercise, right? Like in a civil suit, evidence has been led on certain aspects. So that does count. But, when it comes to criminal matters, the burden of proof is a lot more, right? So, I mean, right? Innocent until proven guilty. So it won't make that much of a difference, but it does obviously carry some. Do we provide the draft issues in the written statement or separately? No, we don't provide any draft issues in the written statement. It's a separate document which we make. It's like a one-pager where we write draft issues to be submitted to the court and just make one line, which we think. And these are neutral issues, by the way. You can't bias the issues and write whether I think Tony Stark is an idiot. No, we write whether the cap shield belongs, who does the shield belong to? Very neutral questions. What is the process called when you exhibit evidence with a red pen? I don't know, Sangram. I do not know this process. I think if you're meaning marking of documents, that is a stage where, okay, so when you're actually presenting the evidence to the court, like when you carry the originals, the court looks at it and then marks it, saying, see, you might have marked the documents as exhibit A, B, C, D, E, F. But in the court, hang on, I'm having some paranormal activity. Hold on. Okay, so in court, when the you give the document to the court looks at it and says, okay, it looks fine. I will mark it as exhibit M3, M7, whatever serial number the court is following at that point of time. But I don't know what the red pen process is. I've never seen that happen. So again, but there's no official stage like that. There was a time during an internship when the registrar subscribed endorsing. There was a time during an internship wherein the registrar quote the main counsel subscribed with. What? I don't understand this question. Sorry, Sangram. Next, a case between a student and a university related to permanent termination of a student is a civil case. It will depend on why the termination has taken place. Okay, if it's ragging and bullying, it falls into the criminal realm. Okay, if it is something less severe or non-payment of fees, it can fall into civil case. So it totally depends on the factual circumstances of that case. Is there any pattern for filing written statement like plaint? Pattern, if you mean rules, yes, there are detailed rules which are set out in CPC as to what you need to do while drafting a written statement. Pattern might be the wrong term. I think you mean rules. So yeah, plaint has detailed set of rules and so does a WS. What happens if you fall under ex parte? You don't get to present your case, Mr. Pandit, because, see, the court will only listen to one side and obviously the court will apply its mind, but then you lose the chance of presenting all the judgments which might have favored you. Okay. Can you differentiate between civil and criminal cases? I did that at the starting. Like, I think I spent a lot of time on that. So I will not answer that again because I want to answer the other questions. What is the process of filing of a stay order? So when you file a suit, right, it is numbered, let's say different courts have different nomenclature. It will be something like CS, civil suit number 1000 or 2020. Give you an example. In that, you file an interim application, okay, an IA number so and so. And in that, the relief which you seek is a stay. Okay, like a stay on BMC from carrying on the demolition activity. So for the duration of the suit. So you basically file an IA. And in that IA, again, you follow essentially the same process as that of a suit, but you don't need to file an evidence in the interim application stage. Like when you file an interim application, the other side will file a reply, and then the court hears both of you guys on arguments. At this stage, no evidence is required to be furnished. Evidence is only required in the main suit stage. Okay. What is the difference between summon and warrant? See, summon is basically demanding someone's presence. Warrant is basically going and arresting someone or searching someone's place, right? Warrant can happen at the stage of, in a civil suit, at the stage of execution, when they're not listening, they're not complying with the decree. And warrant happens very quickly if you're not responding to summons in a criminal case. What is the evidentiary value of legal notice? Nothing. It is, if a thing is that, okay, there are two questions here. If a thing or a fact is, guys, just hold on to the questions, please, because, it's become 51 now from 26. So just like, hang on, okay. What is the evidentiary value of legal notice? If a thing, there's no evidentiary value of a legal notice. It's just you are stating your own fact. You can't have any evidentiary value because you can say whatever you want in a legal notice, right? But you should still attach it. Okay, you have to attach the office copy of the legal notice to your document. A legal notice actually is very important in check bouncing cases. Like if you have not annexed a legal notice, your case is bombarded. This thing keeps moving. Okay, if a thing or fact admitted in reply by defendant, reply notice by defendant, and denied later in. Yes, okay. This question, which I will read it out. I hope you guys can see it too. If a thing or a fact is admitted in the reply to a legal notice by the defendant, this is a good question. Like if a defendant, let's say Tony, Captain America, admits something in his reply to my legal notice, but then later denies it in his written statement and in his evidence affidavit. Is it possible for me as Tony Stark's lawyer to use this as evidence? Yes. It won't carry a lot of value because see, in evidence affidavit as well as written statement, he's doing it on oath. Okay, but in legal notice, he's not doing it on oath, he's just responding. But we can use that to show incoherency in the defendant's case, saying that look, they're completely all over the place, and it creates a presumption of bias in my favor, but not so much. Had he done the opposite, where he's denying legal notice and saying something else in evidence affidavit and saying something else in written statement, that is good because both statements are made on oath. And if he's contradicting his written statement with his written evidence affidavit, that's brilliant for you. Doesn't happen too often, but yeah. What can be done when the party who's summoned by the court cannot make it to the court owing to some legitimate personal reasons? You just make an application by way of your lawyer, which is called exemption from personal appearance. Okay. And then you write that stating, etc., etc. With all these celebrities, they keep doing that. Is there a provision for amendment of plain written statement? Of course, you can absolutely amend your plain, but you have to give reasons as to why you could not, why are you making the amendment? It's not that, any haywire reason you can amend your plaint. You have to show the court that whatever you're amending the plaint with, those reasons or those facts were not available to you while you were drafting that plaint. These are new things that came to information and they're very critical to the case. So you have to make an application for amendment, in response to which the court will then pass an order. Remember, we discussed order versus decree. Sir, is order given on procedural aspects? Yes, it is. Like the whole condemnation of delay for filing a written statement, that's procedural aspect. Inspection and production is clear. What is meant by discovery? Discovery is when there's a reference to a document in the plaint and he has not annexed it, right? Then you can ask the court, make an application that I want to discover this document. What exactly is he referring to? Stuff like that. Criminal matter, civil nature, we have discussed this in detail, so not going. Sir, if without filing the execution petition, the judgment debtor satisfies the decree, then would it be necessary to file an execution petition? This is actually a very interesting question. See, your decree is satisfied. What do you want to do? I mean, it definitely is good to do this. Please always file the execution petition. And when you file it, you tell the court that he has already given the money. And so the execution petition is then served. As it's said, okay, done. The court writes that, okay, everything is done. In fact, the defendant would prefer that because then he gets that solid chit from the court that he has done with the decree. So that definitely helps. Can you please summarize the whole quick session and give a quick brief? Anonymous attendee, seriously? Okay. Hold on. Why is a divorce decree called decree instead of a judgment? Listen, this is family law. It's a little complicated. This is something which honestly I do not know much about. Family law was my least favorite subject in law school, and I'm not dealt with this matter. So I do not know why it might be called that. But I suppose because when you're referring to a divorce decree, it sets out the reasons for which the divorce has taken place, right? I guess that's that, because the judgment will, okay, see, think about it. If the judgment of any divorce proceeding would be divorce granted, right? I mean, assuming it's done and ultimately it comes to a conclusion. So I guess when you're relying on a divorce decree to, prove something, you need the reasons for it. So that's why it's a reference to that. Again, I'm just grasping at straws here. So this is something which I do not know. In moot courts, there is a document called memorial. Is it a practical document in the trial case? Not at all. Memorial is amazing. I loved mooting, but it has there's nothing similar to memorial in civil litigation at all. Okay. But still have fun with moots. Okay. Moots really a lot of fun. If the judgment debtor has already appealed against the decree, then can there be execution of decree? No, but for that, you have to get a stay from the appellate court. Okay, like when you go before, let's say it's a decree of the civil court. You've gone to the High Court, and the High Court has stated that, like, okay, I will stay the execution of decree now. The High Court generally passes the order, so you don't have to worry on that. What is rejoinder and sur rejoinder? Guys, I'll just take 5 more questions, okay, because we've exceeded time. So from here on, 5 more questions. Okay. So what is rejoinder and what is sur rejoinder? Okay, rejoinder. Okay, when I start my argument as a plaintiff, it's called opening arguments, okay, or whatever, primary argument, whatever you want to call it. When the defendant then replies to me, that's called a reply. Okay. Now, defendant might again raise new points. I do not know what points he's going to say, right, in his argument. So or let's say he comes up with a new case law. I want to rebut those case laws. So when I come up again, that's called a rejoinder. Okay. Let's say he wants to come up again. That's called a sur rejoinder. You never go beyond a sur rejoinder. The court will always stop you, because otherwise it'll go ad infinitum, right? So hope that explains it. Sir, please explain about cases where the respondent doesn't file a written statement but files a petition from his side. See, this is what is called a counterclaim. This is again an entire session in itself, so I can't answer that now. But you can Google counterclaim. What does that mean? What does it mean? Judgment based on merits. Merits means the facts of the case. Every judgment is always based on merits. There is no judgment which is not based on merits. Can the court ask to submit the original documents? I mean, the court doesn't have to. The Evidence Act categorically states that you have to submit original documents and everything, which is called primary evidence. If you're submitting secondary evidence, you have to satisfy the rules which are like specified there. Just 1 second. As per your teachings, you stated a judgment means the relief. The order is the everyday status, where the decree is the reasoning. Am I correct or not? See, judgment means the relief, correct? Decree is the reasoning, correct? Order is not everyday status. Order is something which determines more or less the procedural rights of the parties, wherein they can get an interim order which kind of preserves their assets or stops someone from running out of the country. Obviously, that happens in criminal proceedings, but you get the gist. Or some amendment of plaint. These are orders which determines procedural stuff. Everyday status is not the right, but you're in the right path. How to frame charge in civil suit? Charge is the criminal law subject, so that won't count. Okay, last one. Let me see if this is
so Gaurav, we can take more questions later on.
Great, thank you. I'm sorry, guys, I couldn't answer. I think I did answer a lot of questions.
Yeah, we can take more. Yes, you did. We have a lot of questions left also. So we'll take more questions later on because, we have paucity of time.
Yes.
So I'll request Akansha to, get onto the, latter part of the webinar. And then if time permits, we'll take all of the questions that are there.
Okay, great, guys. So thank you so much for listening. I will bid you guys adieu.
Akansha, over to you.
Yeah, I can hear you. It's fine. Thank you so much, Gaurav. Thank you for your...
Thank you, Akansha. Thank you, guys. Have a good time. Thank you, Sangram, by the way. I loved the number of questions you asked. So give it up.
All right. Hi, everybody. 1 second. I think, Gaurav, you can stop sharing your screen also. All right. Thank you. All right. Perfect. So good evening, everyone. We will take your questions. Don't worry. By the end of the session. But for now, as Sudiksha must have already told you about the agenda of today's session, so we'll be covering a little bit about the civil drafting course that we've developed. But before that, just a quick introduction about myself. My name is Akanksha Mishra, and I am currently working at Lawctopus Law School as the head. And I'm going to be walking you through this, briefly walking you through the latest course that we've launched. And in fact, I'm 100% sure if you have joined this webinar, I'm sure all of you are very passionate about litigation as your career. So definitely this course is designed for you, and it will help you a lot in this pathway that you've chosen for yourself. Okay, so without any further ado, let me quickly share my screen and I can then start my presentation. All right, 1 second. All of you do let me know if you're able to see my screen. All right, are you able to see my screen, everyone?
Yes, it's visible.
Perfect, okay. All right. So now the course that we've developed is known as Civil Drafting and Civil Proceedings, or Civil Proceedings and Civil Drafting. And since you all have loved today's webinar, the good news is that the course has been developed and researched and also taught. So one of the faculty members for this course majorly has been taught, researched and developed by Gaurav only. So since you have loved the teachings that he's given, this is just a trailer to all the things that we've covered in this beautiful course. Okay. This course teaches you everything that you need to know about litigation. It gives you a good understanding, especially as a law student. It gives you a very good understanding whenever you start your career, whenever you choose to start your career, be it an internship with an internship, or even if you're just starting professionally. This course will teach you everything about the steps, stages involved in civil litigation, and drafting of all the legal documents. I'll walk you through that also a little bit briefly. But what it is going to majorly do for you is it will definitely save a few years of your legal career if you do this course, because from experience, speaking from experience, I have been litigating, and I was very passionate about litigation. But when I passed out of college and when I actually started going to court, it was very difficult. It took me 2 years to just understand exactly what everything means and how the procedure works. What are these documents? How are they segregated? How are they drafted? What are the stages of civil litigation that I need? It took me too much time to understand these things before I could even start contributing. So for you, that is why this problem has been solved. And for you, we've brought this course, which will give you an understanding and also practical understanding of what are the stages involved and how you can draft these. So that is something that is definitely there. And apart from this, one of the USP of this course that we've launched is that we also are going to give you an internship. The top performers of this course are going to get an internship in a legal chamber also. I will be sharing the link of the post so you can read the name of the law firm as well. We will be giving you a litigation internship provided you perform well in this course, and all the details will be given to you when we welcome you in this course. Okay, so now obviously the question that arises is, what are you learning in this course, right? All right. So just giving you a little bit of brief of what all will you be learning. Rest of the things I'm leaving it to your curiosity. But yes, you will be learning about, as I said, the court machinery, how everything functions in court. What are the stages involved in civil litigation? Just like a small hint that you got in this webinar, it's going to be much more in detail. It's going to be with samples. It's going to be with the actual share screen videos, which is going to show you how to navigate through things, and what are the stages and how do you perform in those stages. It will teach you a lot about legal notices. It will teach you about plaints, drafting of plaints properly. It will teach you exactly how to draft a plaint, written statements, evidence affidavit, interim applications, all of the important legal documents that are involved in a civil litigation. The skill of drafting of each of them will be taught to you very nicely and very efficiently by Gaurav Mohanty. All right. Drafting of Section 65 application, Section 65B application, which is about secondary evidence, right? So, and there are different types of, we've also covered different types of petitions and applications, which are the most sought after petitions. Like, for example, recovery suits, right? If somebody has borrowed money and has not returned that money, so you have the right to file a suit in court, right, regarding recovery of that money. So how do you actually draft such a suit? Similarly, in arbitration, how do you draft an arbitration petition, a petition of claim? Then apart from that, we also have covered Negotiable Instruments Act. I'm sure all of you know that it is so common these days that at least if you are a lawyer, you will start And when clients start visiting you, at least 30 to 40% the cases that you'll get definitely will have negotiable instrument cases where check bouncing cases have come to you. So how do you draft those suits? So things like that have been covered in this course. There are everything has been thought through. All the videos that you see, all the reading resources that you will be reading, all of these things have been designed and researched very carefully for you, so that you are able to kickstart your litigation very well. Also for those who are already into this field and struggling to have these skills, because it's very practical, right? You learn everything on field only. There is nobody actually who's going to actually take you around and teach you something, right? So the seniors are not going to actually pinpoint everything. So this course can actually be a guiding help for you, because I'll tell you why. I'll tell you exactly why this is so much of a guidance for you as well. But before that, there's also an assignment. It will teach you. So we don't just teach things to you. We also expect you to do something, do by learning, learn by doing the exact thing that we have taught you. And then we'll also give you feedback on it, written personal feedback to each and every person. We have a limited batch, right? We don't take too many learners in one batch, just solely for the reason that we could give personal attention to each and every learner, because each one of you are going to draft a plaint or a 65B application. We'll give you a choice. And whatever plaint that you draft at the end of the course will also be checked by the faculty, and personal feedback will be given. Oral feedback will also be given on Zoom. So that way we will know that you are 100% confident to enter into this field and you've learned your drafting. All right. Okay, now as I said, faculty of the course, so Gaurav is one of the person who's done the most chunk of it. You'll find my audio as well. I have also worked on this very hard, because I am still practicing. I have been practicing from the past 5 years. So I have also contributed here. Tushar Giri, another very good advocate. He works in Supreme Court as well as Bombay High Court, and he has also founded his own law firm called Kalp Law. He has also worked on this course, and he has worked immensely and deeply on the legal notice drafting aspect of the course. All right. So you'll find very good content by, these faculty members. All right. Now, apart from this, now, obviously, as I already told you, we already have the placement opportunities at Mahajan and Mahajan Law Firm for you. In case if you perform well, we will shortlist you for an interview. It's a guaranteed interview for sure. We will shortlist people for interviews, and then you can go whenever you go for the interview. If you are selected by the law firm, then you can definitely get the internship. But yes, it's a guaranteed interview from our side. We have a lot of webinars and workshops, so we'll keep informing you. We have alumni groups. You'll become the LLS alumni. So all the opportunities that we have, all the internship opportunities that we have, all the job opportunities, we keep sending people for interviews. We have started our placement cell recently. So all the opportunities go to the alumni. So when you join Lawctopus Law School as a learner, it's not just about learning the practical skills, but also finding your place in the professional world as well, in some way or the other. Okay. So yes. All right. Now, yes, I was telling you that why this could be a guidance stick for you. The reason why this is going to be a guiding stick for you is because, as I told you, you're going to have video lectures that you can watch at your own pace, right? So you don't have to, we'll guide you. It's a 2-month long course, right? So we'll guide you that each week, what is the video or what is the reading resource that you should cover, okay? Cover that within that 1 week at your own pace, at your convenience. And then every week, once you've covered that part, every week in the evening at 8 o'clock, just so that everyone is able to attend it, students as well as professionals, at 8 o'clock, we will have live Q&A session with Gaurav, so that he can answer all of your questions related to that particular module. So each and every step about plaint, about written statement, about legal notice, each and every step will be properly clarified by Gaurav. In case if you have any query, it will be a pure Q&A session because we've covered every learning in the video and in the reading resource. Once you do that, you can ask Gaurav about all your doubts. You can also ask him about his experience so that he can guide you through that exact thing. So you'll get so much more time with him, 1 hour every week, just to ask these sort of questions, just to gain insight over that one particular topic. And this will happen every week for 2 months. In case if you're not able to attend that Q&A session, also, of course, you can attend the next Q&A session, but we will not let you miss out on that live session. We will upload the recording of that live session on our portal. So you will be able to see what people have to say about what Gaurav has to say about the topic and what people have to ask. And you will learn from the other people's experience as well, right? So we'll have recorded video lectures. We have excellent reading modules, which are developed by him and also edited by one of the finest editors of Lawctopus Law School. She's also a topper LLM gold medalist and done a brilliant job in the reading resources. So you will be able to find some very good content in the reading resources as well. You will have an assignment, as I already told you, so you will learn by doing. You also will get a discussion portal, just so that you can ask all your queries, not just in the live session, but also when you're not in the live session and you're just reading and watching the video and suddenly your question comes to your head and you will still be able to write that query on the discussion portal and it will be answered. Not just by the faculty, but even your peers and your co-learners can also answer that question, but it will be verified, so don't worry. And lastly, of course, we'll give you placement assistance, which is the biggest, thing that we've launched along with this course, right? Now, closing session is going to be great. Closing session will not only involve the assignment feedback. So as I already told you, that we will give you personalized feedback in writing. Along with that, we will also at the end of the closing session, we will also give you an oral feedback on your assignments, just so that you understand exactly what you should have done in that problem that you receive. Along with that, you'll also receive some career guidance, whatever experience that the faculty has to share, to give you an understanding, to give you a little bit of light in this career. Because trust me, as amazing as this career is, as fruitful as litigation career is, you require a little bit of motivation to keep going. Again, as I said, speaking from experience, you need a little bit of that spark, somebody to tell you exactly how you can go ahead. And trust me, if you find any person, any mentor, any advocate, or any course that can lead you, that can actually guide you through this path, please grab it fast. Okay. So I can definitely promise you that this course can be one of your companions to help you understand how to move ahead in this career and do well. Okay. Do not give up on litigation. Do not be disheartened just because it's not giving you money right now and it's not giving you, the exact fruits that you want. Trust me, there is a lot more to explore. Okay. I don't know if you're a law student or you're a professional. I don't know if you need to hear this, but there is a lot to explore here. And maybe this course can give you a little bit of a highlight of that. All right. Then, of course, you have certificates. All right. I mean, everyone needs certificates. Everyone likes certificates. So we'll definitely give you completion certificate. But if you do well, if you're a top performer, you not only will be shortlisted for the interview at a litigation chamber, you will also get a merit certificate, which counts as a recommendation letter from Lawctopus Law School, which carries a lot of value and a lot of weight, because even if you sit for interviews on your own, okay, if you go to a litigation chamber and if you're seeking a litigation job, and if your senior sees that you have a recommendation letter or a merit certificate from Lawctopus Law School in the civil drafting course, I'm sure you will get an edge over, selection process, an edge over your peers. It can definitely help you. Okay. No guarantee, but definitely there will be some of the other value. As you already know that we do have a brand in the market. So Lawctopus already has a brand, plus including the fact that you're adding some civil drafting expertise to your CV. will definitely be a cherry on the cake. Okay. And lastly, we will include you in the Lawctopus Law School family as an alumni once you finish this course. And this alumni, being an alumni in LLS really will be wonderful for you, because you'll get to know about all the opportunities, all the internship opportunities, all the workshops, webinars, any type of, any new thing that is coming as an update will be sent to you. And for Lawctopus Law School, it is customized. It is the opportunities that you find in Lawctopus are different. The opportunities which we will give you in LLS will be in addition and will be different and customized for all of you. Okay. So yes. All right. Now, having said all of these things, I would definitely encourage all of you to explore this. All right. And to give you a little bit of a motivation, and also since all of you have been so patient and have been such fun interactive audience, okay, we are going to and since you are already a mini part of Lawctopus Law School in this webinar, we are going to give you a scholarship. Okay, this course is already there, you can buy it, but since you are the webinar attendee, you can use a coupon code. All right, you can use a coupon code to get some good waiver scholarship. Okay, if you register the course today by before 12 midnight, if you register the course, you can use this coupon NSCS20 and you will receive a 20% discount on the amount that on the MRP. All right, but this code is valid only till 12 midnight. Okay, it will expire after that. Okay, if you use it tomorrow or day after, you will have the next 2 days to register. If you register before tomorrow or day after, then you can use the coupon code NSCS15, which will give you a 15% discount. Okay, not a 20% discount, but a 15% discount. Now, obviously, it is up to you whether you want to take the higher amount, higher discount, or you want to take a lower discount. Now that is up to you. Okay, but definitely explore it in some way or the other. I'm sure it will be something which will be of value in your life. Okay, if not, you can also write to me and we can help you in a different manner. But yes, do use this coupon code. Please note it down. Don't miss out on it. All right. So Diksha, I would request you to please send the coupon codes on the chat box as well, just so that nobody misses out on it. So also please write about the duration. So NSCS20 is valid till today. I'm so sorry for the spelling mistake. All right. So valid till today, and tomorrow it is NSCS15. All right.
So NSCS stands for navigating in civil suits. So navigating stages in a civil suit. So if you tend to forget, so you can do that as well. So I'm sending the coupon codes.
Okay, you can feel free to buy the course without the coupon code as well. But yes, I mean, of course, why not? Take the advantage of this. All right. So yes, that's about it about the course. Now, I think, Diksha, I will over to you about rest of the logistics, and then maybe we can see if there are any questions we can address.
Sure. First of all, I'll be sending an EOI form to all of you, right? And if you fill the EOI form, you will also be getting a free, reading resource from our end, just as an incentive to fill the EOI form. So it's an expression of interest form. If you're interested in any of our courses, you can definitely fill the form, and our team or our counselor will, call you for that. Rest, like Akansha said, that everybody loves certificates, right? So we have that as well for you.
1 second, Diksha, sorry to interrupt. Regarding the EOI form, so expression of interest form is an expression of your interest in the course. So currently, majorly, I would be expecting you to show your interest in the particular course, in the civil drafting course. Having said that, if you have any other course as well in mind, you can choose. There is an option in the form. But this interest form will be if we can contact you for the civil drafting course, then let us know in the form. You can fill the form, and then we can, and if you want to know a little more also, I've just given you a small highlight of the course. If you want to know a little bit more about the course and you want to help, yourself take a decision, then you can just fill the form and we'll call you. But yes, calling will happen only tomorrow. So I would really appreciate if you're still even 30% or 40% inclined to explore this course, I would insist that you buy the course today and use the coupon code. Then you can, take more information on it, of course. But if you're anywhere interested, then might as well use the coupon code and then do it today. The rest you can, of course, finish it the next time. Yes, Diksha, over to you.
Yes, so that was all about the expression of interest form. Then next we have, as a conscious that everybody loves certificates. So we have a certificate for you as well for attending this webinar, exclusively for attending this webinar. The link that I've right now sent is for the, certificate. It's a Razorpay link. So you have to pay a nominal amount for the logistics of the certificate, and then we'll be sending you your certificates at the earliest possible. Lastly, all of this information and other information will be conveyed through our WhatsApp group. So if you have not already joined our WhatsApp group, again, I'm sending you another link for the WhatsApp group. Please join the WhatsApp group, because from here on, all of this information, all of the above information will be conveyed via WhatsApp. So even if you, forget the EOI link or the Razorpay link, just make sure to, join the WhatsApp group. I'll be sending the WhatsApp group, link again for all of you, so that it's convenient for, for all of you to join. So this is the WhatsApp link. So make sure to join it. And if you've not already joined it, because that was an option to join it with the webinar as well. So that's it from our end. And I have answered to most of your questions. There are a slightly, the fee would be 100 rupees. So while Akansha was doing the marketing bit of it, I was answering all of your questions. So I hope that, it was a fruitful session for all of you. And, see you again at one of our courses. We'll be happy to host you. So that's
Thank
it.
you, everyone. Thank you so much,
Thank you.
Sophia, for being such a great host as well.
Yeah. Thank you so much for joining. See you around. Have a good night. Bye.
Bye. Oh, we'll also be sending these details on the WhatsApp group. So please join the WhatsApp group so that you do not miss out on these details. All right. Thank you. Good night. Bye.
Thank you so much. Good night. Bye, everybody.